Hello and welcome to my webinar on powers of attorney. I've broken today's session down into three basic elements, which will be the why, the what and the how. So we're going to have a look at why, the reasons why you'd want to have a power of attorney, then going to look at what is a power of attorney in basic terms, what does it mean, and then look at the different types of power of attorney that are available and when you would use each of those. And then finally we'll be on the how, so looking more at the practicalities and like how you actually set up a power of attorney, how they can be used, and things like that. So starting off with the basic question, why would you want to set up a power of attorney for yourself? Why would your clients want to set up a power of attorney? Sort of a background, this quote here, I'm sure we're all well aware that we have an aging population. Obviously events of the last couple of years maybe have slowed things down a little bit, but we are still have a trend towards people growing older, living longer. As this quote here from the Mental Health Foundation, about a number of people aged 65 and over growing by nearly half in the past 30 years. And though that is a good thing, but older people are more vulnerable to mental health problems. Obviously dementia there is the obvious one that we, when you think of old age and you think of mental health problems, that's probably the first thing that springs to most of our minds, are, our thoughts of dementia. I'm sure we all know somebody, if not immediate family members ourselves, or aware of somebody that has suffered from Alzheimer's or dementia, or had problems, especially later in life. And obviously one of the big focuses for the FCA at the moment is on vulnerable customers, and I think certainly elderly people, mental health issues are particularly vulnerable, and so that's a big focus for them. And it's important that we do what we can to protect ourselves, if we're looking at it for ourselves, from our own point of view, our family members, and clients. It is a really important issue. There's lots of cases of financial abuse, unfortunately, with vulnerable customers. That's why it's such a big focus. And having a power of attorney in place is something that you can do really to protect yourself, clients to protect themselves. The important thing really is that you have to do it whilst you have mental capacity to set up a power of attorney, and it gives you control. Now, some people don't think of power of attorney as handing over control to somebody else, but actually it gives you the control because you get to choose who your attorney is. So you get to choose who the person that you trust, the people that you trust the most to make decisions on your behalf, if you're ever incapable of making them yourself. And you can give them instructions in terms of what your wishes are. You can tell them how you want your affairs to be dealt with, so they know in advance, the sort of things that you want to do and your views on things. So it really is should be seen as sort of a way of empowering people to keep that control, even if they do suffer from mental health problems in the future, rather than it being something, oh, you're handing control over to somebody else, losing control. You can turn it the other way, I really think, with this. Obviously, mental health, health deterioration, we do automatically think of older people, because that is most common. But health problems, mental health problems can help at any age. We can have injuries, accidents, brain injuries can happen to anybody at any time. So it is a good idea, sort of for all adults really, to have powers of attorney in place in case of any eventuality on it. If you don't have a power of attorney in place, if there's nothing been put in place and somebody loses mental capacity, then it is too late to set up a power of attorney. What you would have to do instead would be to have a deputy appointed by the Court of Protection. So it gives broadly the same powers as an attorney, but see, the individual that's affected, they don't get that control over who it is, because it's the court that will appoint somebody, and they will often appoint a deputy that is a solicitor, not necessarily, but it could be. The Office of the Public Guardian then supervises the deputies, but as well as you sort of not having the individual concerned, not having that control over who is their deputy, for the people, the family members around them having to put this in place. It's very costly and it's very time consuming. So it can be, things are in limbo in terms of that person's affairs. If somebody's lost mental capacity, so they can't make the decisions themselves, you haven't got an attorney set up, you could have this limbo period whilst a deputy order is put in place, because it is a longer process. So really the message is, this is last resort. It's much better to have a power of attorney put in place in advance to avoid having to go to the court of protection. Right, so moving on to the what then. Basic terms, what is a power of attorney? This is from a campaign. It's been quite a big thing for the government recently, their campaign on here. So a power of attorney is, in simple terms, it's a legal document by which one person, the donor, gives the power to act on their behalf to their attorney. And there are different types of attorney which we'll look at. So we have, first of all, an ordinary power of attorney, a lasting power of attorney, which is probably the most relevant one for to set up in advance of your clients that you're going to be using the most. We still have enduring powers of attorneys in existence, and finally we have a trustee power of attorney as well, which I'll touch on. So first up, we have the ordinary power of attorney. So this gives general authority over the donor's estate, or limited to particular transactions or for a particular period of time. So it can only relate to financial transactions, property and affairs. It doesn't apply. You can't use an ordinary power of attorney for health or welfare. And importantly, it ceases on incapacity. So in terms of thinking about people, mental health issues, this is no use to you whatsoever, because as soon as they lose that capacity, then the ordinary power of attorney will end. What it is useful for, it tends to be short-term things when age and capacity aren't an issue. As an example, going back a few years now, I put an ordinary power of attorney. I gave an ordinary power of attorney to my dad when I went backpacking around the world after I left university, because I was out of the country for a year. So I gave him control over my my bank accounts and so like my credit cards and things. So if I was spending money that he could use my money to pay it off, things like that. Obviously, the world we live in now, with everything being online, it'd be a lot easier, but this was a few years ago. But there are sort of other examples, and it tends to be, yes, somebody's going away for a period of time, maybe somewhere that's less accessible, may not be in communication, that they can have somebody else look after their affairs for a period of time. You can limit it to just like, certain accounts, certain transactions. You can be quite specific on it if you want, but it is only, I say, normally short term. It can go on for an unlimited period of time, but the important thing is that yes, as soon as somebody loses capacity, it's no longer valid. So it doesn't help with somebody with mental health issues. They are no use in that respect. What is of use is the lasting power of attorney. So this is the main power of attorney that we have available now. It came in October 2007. And there are two different types of lasting power of attorney. One relates to health and welfare, and the other relates to property and financial affairs. And importantly, this remains in effect on incapacity. So the fact that somebody loses capacity, the power of attorney can continue, so their attorney can make decisions on either property and financial affairs or health and welfare, depending on which type you've set up. They are two separate, so in most circumstances, you'll probably set up both. And that will continue. It automatically ends when the donor dies, obviously, or if the attorney is bankrupt, because you can be responsible for looking after somebody else's money and affairs if you are bankrupt yourself on that one. So that's the lasting power of attorney, the LPA. We also still have enduring power of attorneys. So you can't set up these anymore. This was the predecessor for the lasting power of attorney, but there will still be ones that were set up before 2007, ones made and signed, which can still be used. So, you will still have clients that have these, I'm sure, and, certainly we see them coming into us. Enduring power of attorney can only be used for property, investments, financial affairs. So there's no health or welfare alternative for enduring power of attorneys. So it may be that you have somebody that has one of these, has an EPA set up, who may also want to set up a lasting power of attorney for welfare and health decisions. So, you know, you could have one of each type potentially on that one. And the last type is the trustee power of attorney. First point before I look at the trustee power of attorneys is if somebody loses mental capacity, they cannot legally act as a trustee anymore. So this does cause problems sometimes from a pension point of view when the member is a trustee. So most obviously is on SAS, where it can cause big issues because all members are meant to be trustees, but if you have if you're not mentally capable, then you can't be a trustee. So that can present some problems. You may well have SAS clients. Also depends on the SIP and how the SIP is set up. You may also have member trustees on SIPs. Quite commonly, if there's property involved, you might have a member trustee on a SIP, or you know, just other schemes set them up different ways. Really, the best thing you can do if you think somebody is losing capacity is for them to be removed as a trustee before they get to that point, ideally before the incapacity sort of is confirmed, you know, point of no return really. So, you know, if it's a SAS, it would be a transfer out to a different kind of pension scheme where they didn't have to be a trustee. Ideally, in an ideal world, sometimes I know that can be difficult. But if you are a trustee, it's important to note that you can't delegate trustee powers under a normal power of attorney. So even if somebody's got a lasting power of attorney or the old enduring power of attorney, or even an ordinary power of attorney if they've gone abroad or whatever, or you want to hand over power to somebody else, they can't use those to delegate their trustee power. Somebody who had a lasting power of attorney who was, say, a member of a SAS, their lasting power of attorney could sign for them anything that needed to be signed, make decisions on their behalf as a member. That would be fine, but not as a trustee. If they're going to make decisions which they are making in their capacity as a trustee, then you need to have a trustee power of attorney. But it's only very limited because it only lasts for a maximum of 12 months. So, you know, again, from a practical point of view, if it's just a case of a trustee is going away, you know, there's paperwork quite often, even with SASs and things, those schemes, we might actually have physical paperwork where they actually need a wet signature still, something like that. If somebody was going abroad for a long period, then maybe they would want to set up an ordinary power of attorney which could delegate their powers as a member. Somebody else could sign as a member, but in terms of their capacity as being a trustee, they would need to set up a trustee power of attorney. But I say, yes, it only lasts for 12 months, so that, you know, it doesn't roll. You can set up a new one every 12 months if you needed to, but you would need to go through that process. Technically, it doesn't cease on incapacity, but you couldn't renew it again, obviously, and it does only last for 12 months. And if you'd lost capacity by that point, then you shouldn't be acting as a trustee. So it's kind of a vicious circle, really. Okay, so on to the how then, on to some of the practicalities. What do you need to consider setting up a power of attorney, how do they work, etc. So I touched on it a few times already. Key point really is that you have to have mental capacity to set up a power of attorney. Once capacity is lost, it is too late. You can have more than one attorney acting on your behalf. You can appoint one or two most commonly, but you could, if you have the two, you could have them where they have to act jointly, or it could be jointly and separately, so they can act independently of each other. There might be certain restrictions, so you can put restrictions in the power of attorney in terms of you only want decisions relating to a certain matter, particularly on the financial affairs. That's probably more likely. But what you can't do is you can't say, well, some decisions can be made by one attorney and some other decisions need to be made by the attorneys jointly. It's either all jointly or all can be done jointly and severally, whichever way around you want to do it on that. Importantly, the donor can still instruct. So just because you've set up a power of attorney doesn't mean that the power of attorney has to act on your behalf. Normally you will have one of these set up, you know, well in advance of actually needing it, you know, if you ever need it at all. And it just means it can sit there in the background in the event of it being needed in the future for the capacity or other reason, you know, in the future, and they want the attorney to act for them. But it doesn't mean that the donor can't just carry on managing their account in their usual way. You know, that's absolutely fine. So it's not handing over control now from day one when you set it up. You can still carry on and make the instructions there. Acting in best interests. So there are safeguards in place. There are statutory principles that attorneys have to follow. The main one being that decisions have to be in the donor's best interests, and they can't, as an attorney, you can't delegate decisions to somebody else. There's a little bit more, I'll come back to that one on acting in best interest in just a moment. Another key point is about having separate donors' money. So there's no point really should the attorney's money and the donor's money be mixed together. So for example, if somebody has a power of attorney set up on one of our accounts, whether it be a SIP, an ISA or a GIA, and the attorney can give us an instruction that they want to make a withdrawal, that withdrawal would still go into the donor's bank account. We will still make that payment to the donor account in their name, not directly to the attorney, because those monies need to be kept separate still. Obviously, the attorney should have access to the bank account if they need to then make payments to whoever to pay bills or whatever it is on behalf of the donor. But the important thing is it is still the donor's money, so it should always be separate to the attorneys on that. Last point on certified copies. So when you once you've set up a power of attorney and you need to send it off to a provider so they can use it, so the attorney can have control of that account, give instructions on that account. There are specific rules in the Powers of Attorney Act 71 about who can certify copies. So the donor themselves can certify a copy whilst they still have capacity. So it's a good idea when you set up a power of attorney to have a few copies that the donor signs every page on it, certifying that this is a true and complete copy of the corresponding page of the original, and then at the end of it, on the final page, certify this is a true and complete copy of the lasting power of attorney. If the donor can't do that because they've lost capacity, then it needs to be done by a solicitor or a notary public. They can also certify copies on it. Those are the only ones which are acceptable under the legislation, under Powers of Attorney Act. So you as the advisor can't certify the copies, I'm afraid, and that's written in the law, so it's not us trying to be awkward or anything on that one. Coming back to the acting in best interest one, so the most recent relevant legislation to this is the Mental Capacity Act 2005, and when this came out there was an accompanying code of practice. So this gives into a lot of detail of the practicalities. So in terms of what best interest or acting in best interest of the donor means and what you can and cannot do. One particular area which sort of comes up is in relation to gifts and making gifts on behalf of the donor. So the basic rules are that attorney can make gifts to family members or somebody connected to the donor, so it could be a close friend, on customary occasions. So you think of that, birthdays, weddings, anniversaries, Christmas, Diwali, Chinese New Year, whatever the appropriate, religious festivals as well might come under that, or to a charity which the donor has previously supported. In terms of the amounts, it has to be reasonable. This reasonableness test, so it kind of will depend obviously on the size. What's reasonable to one person won't be reasonable to somebody else in terms of how it affects their standard of living, what other assets they have, etc., etc. Care is needed in terms of deprivation of assets. You can't give all the money away to avoid them having to pay for care costs, things like that. And if there are any gifts which are wanting to be made, which aren't on a customary occasion or are of a significant amount, then you have to go to the Court of Protection and basically get it approved, apply for authorization in advance. And you do have to be careful with this. There was a case which just was reported on at the start of this year, very recent case of Chandler versus Lombardi, where there was, it was a daughter who had power of attorney for her mother, and she had gifted herself, well, her mother's house had been solely in her mother's name, and she transferred it into joint names on a joint tenancy basis with her, with her mother. And obviously when her mother died, this came to light, and her 3 siblings hadn't previously been aware of it. And basically the case came out, and it had to be undone. It wasn't a lawful transaction. So, you know, something like that, she clearly, the size of it, she would have had to have had approval from the court to do that, which probably wouldn't have been given, but yeah, she shouldn't have done that. So yeah, you do have to be a little bit careful, but you know, code of practice, that's where to look if people are wondering what they can and can't do in practicalities. So in terms of completing the paperwork, how do you put these in place? Ordinary powers of attorney, there is no standard form to complete. We just have this wording from Powers of Attorney Act 71, which must be quoted, signed as a deed and delivered, and then it can be used immediately. It doesn't have to be registered. It's very straightforward, very easy one to put in place. That and it's very similar actually for a trustee power of attorney, which is covered by the Trustee Act 1925, which again, it's got specific wording on it. It needs to be done as a deed. It doesn't need to be registered anywhere. It can be used immediately. So they're very straightforward to put in place. More of a process, sort of process when it gets to lasting power of attorneys. And I say this is the one which will be most appropriate, of most use. So these are forms which you have to get from the Office of the Public Guardian. They have standard forms, one for property and financial affairs and one for health and welfare. You can fill it all online, or you can fill it online and print off the forms, but it does have to be obviously signatures signed on it, and done in the right order. You can nominate more than one attorney. So as I mentioned previously, you can have one attorney, or 2 is most common, but you can also put replacement attorneys, so that if one of the attorneys predeceases the donor, the replacement attorney steps in without you having to redo it, which obviously you might not be able to redo it if the donor has already lost capacity. So it could be a good idea to do that. You have a certificate provider who, certificate provider is basically there to, as an impartial person, to say that the donor has not been put under any pressure to sign this, that nobody's exerting pressure, you know, telling them they have to hand over the power to them as attorney, anything like that. So it needs to be someone who's known the donor for more than 2 years, or a professional person, like a solicitor. And then everybody must sign in the right order. So the donor has to sign it, the attorneys have to sign it, the witnesses have to sign it, and the certificate provider as well. Once that is done, it then has to be registered with the Office of the Public Guardian, which at the moment it takes about 20 weeks, according to their website when I just had a look at it, as at time of recording. So it's about 20 weeks at the moment, and it only comes into effect once it is registered. It can't, you can't use it before then, before the process is finished. Now, on the forms, there is a little box to tick whether you want it to only come into effect on mental incapacity. So this is optional. You can either leave it blank, in which case it comes into effect immediately it's registered, or if that box is ticked, you can only be used once the donor has lost capacity. Now, I can understand why people might want to tick that, because, you know, if they want to keep control themselves whilst they are capable, that's fine. But one thing to bear in mind is if that box is ticked, it does mean that in order for the attorney to use it, they will have to provide evidence of that mental incapacity. You know, so it's just an extra step that they have to go through to get that medical evidence of the incapacity before, and to be able to provide that before they can use the power of attorney. So it doesn't mean that they shouldn't do it or shouldn't take it or whatever. It just means you need to be aware of it, that they will need to do that if that box is ticked. Obviously, the donor can cancel a power of attorney at any time whilst they have capacity. They can notify the Office of the Public Guardian and the attorney in order to do that. In terms of cost for these, at the moment they cost £82 each to register a lasting power of attorney. So if you're going to do a property and financial affairs one and a health and welfare, you pay that twice, so it's £164. There are reductions for those that earn below 12,000 or on certain benefits, income support, etc. Then they can get reduced rates on it. Okay, nearly there. Enduring power of attorney. This one, say you can't put it in place anymore, so it's an easy one. It can't be done. But in terms of the practicalities on how you use it, if the donor still has mental capacity, then it's like an ordinary power of attorney. So you can remember, you can only use these for financial affairs. You can't use it for health and welfare. So in that sense, it's more like an ordinary power of attorney. If it's not registered, because an ordinary power of attorney doesn't have to be registered either. But if the donor loses mental capacity, you can still carry on with your enduring power of attorney as long as it's registered with the OPG, the Office of the Public Guardian. If it's not registered, you can use it up until the point they lose capacity, if there's no limits written in it on the attorney's powers. Obviously, it will automatically end on incapacity if you haven't registered it, and again on the death of the donor or the attorney, or the bankruptcy of the attorney. You can cancel it just by a deed of revocation if you haven't registered it, but obviously if you have registered it, you do need to notify the Office of the Public Guardian as well as the attorney in order to do that. Right, last point on this then. What I've been talking about is mainly the situation for England and Wales. There are some differences, slight differences, when we look at attorneys in Scotland and Northern Ireland. So ordinary power of attorneys in Scotland and Northern Ireland are broadly the same as in England, as I've talked about, but lasting and enduring power of attorneys do not exist in Scottish law. Instead, they have what they call a continuing power of attorney in Scotland, which is for property and finances, and a welfare power of attorney in Scotland. Another thing that's slightly different is the fact they don't talk about donors, they talk about grantor. Grantor just means the same as donor, really, under Scottish attorneys. For continuing power of attorney, so the financial affairs ones, made after April 2001, the deed has to expressly provide that the attorney's powers can continue beyond the donor's incapacity. So it has to state that in it, or else it would cease. They also have to be registered with the Office of the Public Guardian in Scotland for it to be able to continue once capacity has lost. Some of them may also have what's called a springing clause, where they only come into action when capacity is lost. That'll depend, not all of them will have it in there, it depends how they've been set up on those ones. Northern Ireland then, general power of attorney is broadly the same. They have an enduring power of attorney, but it's a slightly different one. It's not, strictly speaking, the same enduring power of attorney that we have in England, and obviously it is still ongoing now on that. It can become effective immediately or only after it's registered, depending on how the donor would like it to be set up. But either way, it needs to be registered on incapacity on that one. Right, so quick summary. My key points then, really, the important thing with powers of attorney is act before incapacity. So put a power, getting powers of attorney in place. I would really emphasize the point that it gives people control rather than just like handing over control, because you get to choose who you want to be your attorneys, rather than ending up with court protection if capacity was lost. So yeah, really gives the client that control. Lasting power of attorney is the one which you're going to use, which can cover most situations, because you can have a property and financial affairs and a health and welfare lasting power of attorney. If you do have clients that are trustees, there is very limited ability to delegate trustee powers. If somebody is heading down the route that you think they might be losing capacity, ideally you want to remove them as a trustee, resign as a trustee, appoint somebody else, get them out of there before they lose capacity on that. But that is all from me for today. So thank you very much. I do hope that has been useful. Thank you.